Mr. Kitchens, where are you, sir? Raise your hand if you can hear my voice. All right, thank you, sir. All right, we're here on the record in the matter of the state of Georgia versus Sergio Kitchens in 22 SC 183572. Good morning, Ms. Love. Good morning, Mr. Samuel and Mr. Sadow. All right, so I have in front of me your third motion for bond, and I have read and considered it. So if you want to go ahead and flush it out a little bit, Mr. Sadow, and to begin with, thank you for your patience, sir. I understand there's a time delay or lag of where you are, so appreciate you being patient with us, okay?
Acceptable, and then held specifically that bond was denied for two reasons. One, because the defendant, Mr. Kitchens, posed a significant threat or danger to any person in the community or to any property in the community. And two, because the court found that Mr. Kitchens posed a significant risk of intimidating witnesses or otherwise obstructing the administration of justice. So those are the two factors that we're going to focus on today, Your Honor.
Okay, all right.
Since that time, he refers to Mr. Williams. So whatever the state's position was on Mr. Kitchens in Overt Act 75, when it argued to the court, the court should, at this point, just kind of put aside and understand that I'm not going to suggest that what they were saying was false, but clearly they don't have the evidence to support Overt Act 75, which was the overt act that dealt with supposedly violence in connection to Mr. Kitchens. In addition, there were new charges brought, and the new charges that were brought are interesting because in Overt Act 182, a gentleman by the name of Cardorvius, I may be mispronouncing it, Mr. Dorsey, was added, and he is described as a leader of YSL. Now, the court may remember the first time in count 56, Mr. Williams was described as a leader in YSL. Now, Mr. Dorsey is described as a leader in YSL by Overt Act 182. The significance of that is Mr. Kitchens is not, even in the re-indictment, is not described as a leader of YSL, although the state has argued that to the court. In the re-indictment, they've chosen not to make that allegation, so we don't have any basis for that at all. In addition, I'll take you back to Overt Acts 68 to 72. Those occurred in September of 2017. So we're talking about 5 years ago. And those are the acts all on the same date, September 24th, 2017. That's the one that the state tried to argue to the court had to do with misconduct, criminal activity by Mr. Kitchens. And we repeatedly have told the state, and now just one more time, Mr. Kitchens entered a plea to a window tint violation on those allegations on 9/24/2017. That case is completed in DeKalb County. Whatever they want to say about anybody else that was involved in that case, it's fine. But Mr. Kitchens is a window tint violation. That case is over with, and it's 5 years ago. Your Honor may remember, since that time period, there was allegations that the former assistant district attorney that was handling this matter, who was apparently moved on, that there could be something coming against Mr. Kitchens, potentially related to violence in connection with other matters. That was in July. It is now 3 months later, August, September, October. Nothing has been brought against Mr. Kitchens in connection with any act of violence in any other jurisdiction for any other conduct. So they have not followed up on that. And I think the court can consider that in making its determination of whether or not there is still significant risk that is the state's met its burden of persuasion. Taking it one step further, Your Honor may remember there was reference to a nurse in Fulton County. A hearing we had last month actually set a date of September 23rd when the state would have to give us any statements or proffers made by cooperating gang members. And that was important to us. And the reason for that is we had been through all of the discovery that had been turned over so far. And up to that point in time, there was one person that had even mentioned Mr. Kitchens. So come September 23rd, I guess our expectations were that we would receive more because of all the allegations and the proffers that the state had made. September 23rd came and went, and we were told by the state that we had everything that had to do with Mr. Kitchens when it comes to cooperating gang members, proffers, and statements. And the court, will remember, it put a 14-day time period on updating. That 14-day period of updating went by last Friday, and nothing additional has been turned over, and the state has told us at this point they have nothing else in discovery on Mr. Kitchens that has anything to do with gang members cooperating or proffers. So what we say to the court is we made a burden of production presentation back in May in which we outlined, you might remember we gave you a book, Your Honor. There was Exhibit A, had suggestions that we had made for bond. We had all the individuals that had done affidavits. We stand on that. We think the circumstances are such now that the state is unable to meet its burden of persuasion, and that the suggestion of significant threat of danger to the person in the community or property in the community or intimidating witnesses or otherwise obstructing administration of justice has fallen by the wayside. They've not been able to back up. They had repeatedly told the court they were still investigating, they were still investigating. They don't have that for purposes of bond. And I believe, therefore, we have a change of circumstances, which the court had invited us to bring back to the court's attention. We are attempting to do so. And I believe under those changes that bond is now appropriate, and we would stand on the same bond proposal that we had made way back when, which I think is Exhibit A to what we put forth to the court at the first bond hearing in May of 2022.
Yes, sir, that still would be correct. All right, anything else, Mr. Sadow?
Your Honor, at this time, there's been no change in circumstance that would warrant the defendant getting a bond. The only thing that has happened since the court last denied the defendant's second request for a bond is that in Henry County, he attempted to obtain habeas relief. That was denied, and then he appealed that to the Georgia Supreme Court, who then denied his appeal for the denial of the relief, of habeas relief. Mr. Kitchens was a participant in Overt Act 75, and in looking at the new indictment, I do see that his name apparently has been inadvertently left off, but that does not in any way mean that the state is now suggesting that he was not a participant in that act. This is a case wherein we have circumstances involving attempts to serve witnesses who frankly break down and cry out of fear that harm will come to them if they are required to come into court and testify.
Does testify against Mr. Kitchen or testify as in
general, Your Honor. I will
okay.
not say that we have told them you will have to come and testify against Mr. Kitchens specifically. We have evidence that there are members of this organization that are named in this indictment who have in fact conveyed their willingness to whack or to kill a person for the defendant. And given that there has been no substantial change in circumstances, we would ask that the court deny the defendant's motion for bond reconsideration.
Now, when you mean the last statement you made, whack or otherwise, who are you referring to? Are you referring to Mr. Kitchens? You referring to Mr. Williams? Or who are you referring to? Or the
Specifically, one of the other co-defendants expressed, asked that the defendant Kitchens be made aware that he would be willing to whack somebody for him. And that's just what was found in the evidence that we've been going through so far. We continue to sift through the evidence. statements like that cause us concern for, the real threat of witnesses feeling in some way influenced, pressured, intimidated. But even if it is not a request from Mr. Kitchens, hey, go out and do harm to this person on my behalf, when there are people who may feel like it would do him well to have things done to other people on his behalf, and they're gunning for, favor in his eyes, those type of things cause us a real concern. So we would ask that the court, based on the fact that there has been no change in circumstance, deny the bond reconsideration motion.
Okay. Your Honor, that we are once again getting this vague information, all by virtue of proffer.
Okay, but
each
a proffer is authorized
I understand.
under Title 17 at this point in time. It's a different standard than
I understand.
trial standard of beyond a reasonable doubt. And you all know, being seasoned advocates, that the state has to prove these assertions beyond a reasonable doubt at trial, as pursuant in the indictment.
Judge, I'm not questioning their authority to proceed by way of proffer. And in fact, that is the only thing that was decided in the Henry County habeas, and the Supreme Court denied review. I'm pointing out by proffer, and the reason it's important in this case, Your Honor, is this is what has happened now at three different hearings. They've gone by proffer. It's every single time they've made a proffer of the evidence that supports the state's view that there's a significant risk of danger. It's been disproven. The proffers are not reliable. They can proceed by way of proffer at their risk. They proffered the nurse testimony. It turned out not to be true. They proffered evidence about, something going on in Clayton County. Nothing ever happened. They proffered evidence about, each time Mr. Geary was saying, well, we have new evidence now. We have new information we're trying to develop. And then we go and try to find out if there's any support for it, and it turns out there's not. And then when they turn the discovery over, it's not there. And now they're saying, first of all, they say that the only thing that's new is Henry County. What Henry County established, the proceedings in Henry County, was that they can proceed by way of proffer. But we're asking you to be somewhat skeptical, Your Honor, when time and time again the prosecution has made proffers of what the evidence is that supports a denial of bond, and when we go and try to find out whether there's any truth to it, it turned out there's not. In the brief that we filed and submitted to you, we showed every single proffer they've made in the two prior hearings. You've got the transcripts. We've quoted at length from the transcripts for Mr. Geary, and then showed how it ended up not being true. I'm not saying Mr. Geary was lying, because he would repeatedly say, we're not sure about this, we're investigating this, and he was very careful about that, and I respect that, and it's appropriate that he did that. And there was a reason he was uncertain about it, because it ended up not being accurate. Mr. Kitchens is presumed innocent. He's been in jail now since May, into October. We're talking about a trial at best that will start in January and may go until the summer or the fall of 2023. At some point, we are asking you to demand of the prosecution, what is the evidence that's holding this man in jail without bond? We learned today for the first time, even though we filed our brief, 3 weeks ago, that the new indictment has a typo in it. And that's why apparently paragraph 75 omits Mr. Kitchens. They could have, let the court know about that previously. They could have responded to the brief. It's right in there in footnote. We highlight it because that's what you thought was important from the first indictment. They have yet to stand up and say the DeKalb County statements that they've been making repeatedly, that he's still, involved in this DeKalb County case. I was his lawyer in the DeKalb County case, where you've told them repeatedly that there's no charges pending against Mr. Kitchens in DeKalb County, and yet Mr. Geary repeatedly told the court, including at the last hearing, that the case is back from the Court of Appeals against Mr. Kitchens. It's not.
Your Honor, may I also address very quickly, just to respond to this discovery order that suggests that co-defendant has ever made such a statement, be it proffer, be it statement, be it cooperation. All we're trying to do, and Don is advocating it the same as I am. We've done everything the court has asked to try to show that they're really, from Mr. Kitchens, I'm not talking about anyone else, that he doesn't pose the significant risk. If there are others out there that the state has evidence on and wishes to bring it forward, I understand that. What we're talking about is Mr. Kitchens and Mr. Kitchens alone. And you have, I know, Your Honor, from your other bond hearing, you've talked about criminal records and conduct. Again, in this situation, you're talking about 5 years ago, a window tint violation. And I find it hard to understand how Mr. Kitchens just fell through the cracks on overt Act 75 when all they had to do was copy what was already there. It's a lot easier for them to say it, but they didn't re-indict it after they saw he wasn't there. They let it sit. So we're before the court on what has presently been made available. This is one of those times in which the court exercises discretion appropriately in its own mind. We understand that, but things are different. And as Mr. Samuel pointed out, the only thing that was litigated in Henry County was the proffer issue, which is why when the court is saying proffers are acceptable, we understand that. We're not challenging that. We're just saying they no longer can meet their burden of persuasion to show, as they must under IALA, that he poses a significant threat or danger or risk, and it's been outlined in the past.
The circumstances upon which bond was denied previously have not changed. The context that the statement was made in, and I do not want to, I would be happy to reveal to defense counsel and to the court, not publicly, whose phone it was found within and more specifics about that. But it was simply, I believe, one co-defendant wishing this defendant a happy C-Day, if I'm not mistaken, and imploring a person to tell Gunna that this person would whack someone. I would still whack someone for you. So it's not that we're asking that the court deny bond based on that text alone. It's just part and parcel of the reasons why we're asking that the defendant not be granted bond based on this third request made by defense counsel.
Okay. Anything else, Mr. Samuel?
Your Honor, I'm alleged to have done anything. I mean, I suppose I could say I would do anything for my good friend Brian Steele. I'd do anything for him. And then the next thing you know, Brian Steele gets denied bond because I said that? That doesn't even make sense to say you're going to be denied bond. You'll spend, the better part of 2 years if this case goes to trial next year and doesn't end until the end. A year and a half because someone else said that they would do something. That's not even an additional reason for bond. And the prosecution says we are relying on all our previous assertions. The previous assertions have all turned out to be hollow.
Okay, all right. Anything else? I just got to do what I got to do. All right, Mr. Sato, anything, sir?
No, Your Honor, thank you.
Okay, all right. Here's where the court's kind of, where I think all of you are kind of stuck between. There is the standard for bond, which is the preponderance of the evidence. And then there is, and that proffers are authorized by our state Supreme Court for bond. They are not offered or not authorized unless otherwise agreed to for trial, and that strict burden or strict proof is required for that particular proffer as a result to a issue of proof at trial. So we're stuck in between the two burdens in this case. We also acknowledge the fact that the defendants are presumed to be innocent, and this particular system authorizes the court to consider bond based on based on statute as well as case law. And, and I have done so in in this particular case and will continue to do so. The other challenge that our imperfect system kind of just, hasn't figured out a way to kind of deal with other than reconsidering the issue of bond and changing circumstances of bond is acknowledged for proof that may or may not come at trial, but the state bears that burden at this point in time. And it's not a perfect system in the sense that we won't know until that time whether or not many of these statements that have been proffered by the state come to pass or come to fruition. That's no consultation or consolation for your client, Mr. Samuel and Mr. Sadow. And but unfortunately, that's the best that the system can offer at this point in time, given the status of the case law and the like. The only thing I can potentially do is, like I said, I will try the case as expeditiously as possible. But at this point in time, I don't find any change in circumstances that would allow me to or move me from changing my decision as to bond. And if anybody's in the gallery and you can't otherwise control yourself or otherwise you want to make any appropriate comments, then you can leave at this point in time. No harm will come or nothing else will occur. But if you remain in this courtroom and make any outbursts, I'll have you arrested.